We are very fortunate to have Robbie Sarles here with us today to present on the updated USDOT drug and alcohol testing regulation. Robbie is president and owner of RLS and Associates, Inc., which provides transportation management and operations consulting services to transportation providers throughout the United States. She's a nationally recognized trainer and an expert in the Federal Transit Administration drug and alcohol testing regulations. Robbie is principal in charge for statewide drug and alcohol testing regulatory compliance assessments for 13 states and has conducted over 1,000 drug and alcohol program assessments, policy reviews, and training programs nationwide. She writes for the FTA-published Drug and Alcohol Program Quarterly Updates and was one of the co-authors of the Implementation Guidelines for Drug and Alcohol Regulations in Mass Transit and the FTA Drug and Alcohol Best Practices Manual. Ms. Sarles completed a master's in transportation engineering at The Ohio State University, a master's in city and regional planning at Ohio State University, and a bachelor's of science in geography and psychology from Western Kentucky University. I could go on about Robbie's experience, but suffice it to say that she is an expert in this field, and we're lucky to have her presenting today. Sean Oswald is also going to be on the webinar and is fielding questions. He is Senior Associate at RLS and Associates and is Project Manager for RLS's Drug and Alcohol Program engagements. So without further ado, I'm going to turn it over to Robbie, and she's going to be showing her screen today. So just give us one moment. Okay, I can see your screen, Robbie.
Great. Well, good afternoon, everybody. Again, this is Robbie Sarles with RLS and Associates. I'm glad we have so many people signed on. Obviously, there's a lot of interest in this regulation and what it's going to mean in the very near future for all of us. I really want to start off by first clarifying for everybody and making sure that it's clear that this presentation is made by RLS and Associates Association with National RTAP, that we are not officials or representatives of the USDOT or the USD Office of Drug and Alcohol Policy and Compliance, nor the FTA. So the opinions and the interpretations that are provided within this presentation are those of the authors of this presentation and do not in any way constitute official guidance from the Federal Transit Administration or the Department of Transportation. That being said, we're going to go ahead and get started here. We have a lot of material to cover. What we're going to try to do is give a little bit of the background, give a summary of the changes, and then try to summarize workplace or the impact that's going to occur on the workplace. Then we'll have hopefully a little bit of time at the end for questions and the like. One of the things that we have done is through this presentation, have attempted to make it very clear where we interpret that there could potentially be an action item that employers may need to implement. Again, some of these things, if it's a situation where the regulation indicates that it's a requirement, we'll specify that, but most of the action items are going to be things that we recommend as best practices. I will absolutely do my best to make sure that those points are clarified, but if you see a red star on your screen, that might be something that you might want to make sure that you're taking notes of and listening and taking special attention to. So there's that red star. The background. So why are we here? Well, we know that 49 CFR Part 40 is the USDOT's drug and alcohol regulation. It really covers testing procedures. It covers the how to do the testing. And so that is the part of the regulation, that is the regulation that has been updated. That is the part of the regulation that we will be discussing today. So the when. Well, first of all, there was a notice of proposed rulemaking that was published first in January of 2017. That rule, with some minor modifications, became final and was published in the Federal Register in November of 2017, with an effective date for all changes occurring January 1 of 2018. So we have a fairly short time frame to be prepared for this effective date of January 1st, 2018. The who. Again, the regulation is 49 CFR Part 40. That means it covers all DOT modes, including FTA, Federal Transit Administration, FMCSA, railroad, aviation, pipelines, Coast Guard. So essentially all of the DOT modes are covered by this change to Part 40. Anyone subject to Part 40 is in fact subject to this change. It has implications for employers, for employees, for medical review officers, substance abuse professionals, and collection sites. The biggie, the one that is the one that the folks were looking for, and there were a lot of positive comments in the proposed rulemaking process with substantial support, and so the final rule does include an expansion of the opiate panel to include 4 new opioids. Another thing that will be important is we've got a change in language now, given the fact that we've added these 4 new opioids. So now that is going to be the term that we're going to use going forward. The reason why there's a red star here is because any literature that you have, any policy that you have, any information that you provide your employees regarding the testing program, you will need to incorporate that change in terminology. So the term opioid is out and the term opioid is in. Okay. These are the 4 new opioids that are going to be added to the testing panel. Hydrocodone, hydromorphone, oxycodone, oxymorphone. Again, with common brand names such as Vicodin, Loratab, Dilaudid, Oxycontin, Percocet, and the like, and you can see them all listed here. Another change is that they have modified the panel as far as how it relates to ecstasy. So they've added MDA to the screening test, but they've removed MDA. Primarily because of the additional cost and complications associated with the testing and the amount of usage of those particular substances. Okay, so MDA has been added to the screen, but MDA has been removed. Also, they took this opportunity in this final rule to revise and update several terms and definitions. The reason why we have a red star here is because many of you in your policies may have a definitions section. If you do, then you'll want to make sure that your definitions are updated given these revisions. One of the revisions, for example, is the referral to the term DOT, the department or DOT agency. That means it's really encompassing all DOT agencies and any designee of a DOT agency. It also does clarify the Coast Guard's relationship with the DOT. Again, when we are now referring to the word drugs, depending on how you might have that worded in your policy, but drugs now include the addition of the 4 opioids that we just spoke of. Alcohol screening devices and evidential breath testing devices are now, currently, the list of those are published periodically in the Federal Register. Now, instead of that method of listing and notifying folks of those devices, now that list of approved devices is going to be on ODAPC's website to make it easier and more accessible for folks. So again, if you want to know what the current list of approved devices, alcohol screening devices, and evidential breath testing devices are, you will need to go now to ODAPC's website for that list. Similarly, when it comes to substance abuse professionals, there's a list of qualified agencies for drug and alcohol counselor license and certificates. There may be need for more fluidity in who meet those definitions, and so to ease that, there are now going to be publishing that on ODAPC's website to give a little bit more flexibility in defining the qualifications for a substance abuse professional. Again, in the ODAPC's website going forward. The regulation also requires now that all service agents, that means medical review officers, substance abuse professionals, urine specimen collection folks, breath alcohol technicians, all service agents are now required to subscribe to the ODAPC listserv. And again, as a reminder, ODAPC stands for the Office of Drug and Alcohol Policy and Compliance. So they do publish a listserv when there are changes in the regulation, and so now service agents are all required to subscribe to that to make sure that they are informed of the latest changes. On the screen, you will see that that site, and if you go there, you'll be able to very easily follow along, and we'll find how to subscribe. As an action item, a best practice is for employers to make sure that their service agents are, in fact, actually doing that. So again, the regulation does not require it, but it would that the employers notify the service agents, but it would be a best practice for employers to ensure that their service agents have, in fact, done that. Another important clarification and change has been revolves around the inappropriate use of the FTA or DOT logo or any of the federal branding associated with the drug and alcohol testing program that might in some way mislead folks that other programs or other policies or other things actually are a product of the federal government. And so because of that confusion that has occurred up to this point, this regulation has made it very, very clear that all entities, all service agents, everyone are prohibited from using any reference to or inclusion of any logos or anything that would imply or mislead folks that those items are in fact a product or endorsed or certified by a federal or DOT agency. So those are all prohibited. The reason why there is a red star here is that on occasion we might see forms or other maybe training materials or various and sundry things where perhaps a DOT or FTA logo might have been used on those forms. So we want to make sure that it's very clear that those products are not endorsed nor certified by the federal government, and so those need to be excluded and they're prohibited from use. So you need to get those removed if in fact they are there. Also, For the larger entities that had to conduct a number of tests, blind specimen testing has been a past requirement, but as of this effective date, now blind specimen testing is no longer required as part of Part 40. Additional changes is one of the things that was critical is that there were a number of different definitions in different areas regarding the definition of prescription, and so it was determined, and this regulation adopts the definition of prescription that was used by the Controlled Substances Act. So going forward, that is the definition of prescription that going forward. Also, there has been some issue with various test results that might have made some question, and perhaps MROs may have needed some additional information in order to determine whether a substance was legitimately present or not. And so this regulation basically is making it easier and making it more flexible for the MROs to do that additional testing without prior ODAPC consent. So, for example, if an MRO finds an issue and there's a concern about a potential methamphetamine false positive due to donor prescription or over-the-counter medications, that MRO has the authority to go ahead and require that testing without getting ODAPC consent. The same thing with additional testing that can make the distinction between illicit THC and Marinol. One area that folks have some significant concern about, and I'll come back and address this a little later in the presentation, but revolves around the medical review officer's verification of prescriptions in that process. First of all, I'd like to indicate that the majority of this process is the same as it's always been. There was a little bit of an addition here that we're going to talk about in a second, but this is primarily the same as far as the provisions have always been here for a medical review officer. So what we tried to do is to break it down into steps so that individuals could follow along with what is going to probably be happening here. And so the first thing that's going to happen is when a medical review officer gets a test result back from the laboratory, they're going to go through the normal process that they always have to verify that test result as either positive or negative. There's been nothing that has really changed with that process. Should, however, a result be verified as negative, the MRO also will be making a potential determination that if there is an indication that a prescription medication may have been used, as we know, as long as there's a legitimate medical use for that prescription, it's going to be reported to the employer as negative. There's also the requirement, as there always has been, that if in reviewing that, the MRO has determined that there could be a significant safety risk in their professional opinion, that MRO is now going to notify the employee of that potential significant safety risk, or also if there could be a violation of any of the modal safety requirements as well that might make them medically unqualified. So the MRO will verify the test as negative or positive. If it's negative and if it's viewed that there could be this potential safety risk, they will communicate that to the employee. Step 3, and again, these are our steps, not the DOT's, but what we view as the next step that is going to occur, and this is the new part, okay? Once the employee is notified that there could be this potential safety risk, Now the employee has a 5-day period to facilitate contact between their prescribing physician and their MRO. So the burden is on the employee to get to their prescribing physician and have that prescribing physician contact the MRO so that there can be a discussion from medical professional to medical professional about the potential safety risks that are associated with the use of this prescription medication. The discussion between the prescribing physician might revolve around the individual's use of this medication, how long they've used it, generally speaking, whether or not the prescribing physician believes that there's a safety risk or not. It might also revolve around whether or not there might be an alternative dosage or directions for usage, or perhaps even another medication. The goal here is to have the two physicians, the MRO and the prescribing physician, make a determination about whether or not that safety risk whether there is a safety risk or not, and if there is, if it can be mitigated. And so that's why there needs to be that MRO prescribing physician discussion. If in fact, after that discussion, the MRO believes that there is no safety risk and therefore the MRO's concerns have been addressed, then they will just, there's no additional notification of the employer, and the employer has not been notified and will not have any information about the MRO's initial concerns. However, if after the MRO has had their discussion with the prescribing physician, it's determined that there is still the possibility, there's still a safety risk, or that there's this additional concern, then at that point, the MRO will make that determination and they will contact the employer, indicating that this individual, even though their test was negative, that there's a potential safety risk associated with this particular employee performing their safety-sensitive duties. Additional provisions of the regulation is that the DOT made it very clear that there are no other allowable specimens other than urine. Again, perhaps DHHS is allowing other procedures for other federal workplace employees, but that is not the case with the DOT. So all DOT covered employees are the only testing that is allowable is urine. So there is no blood, hair, sweat. There are no other options. Also, the regulation makes it very clear that the specimens that are collected as part of this testing process cannot be used for other purposes such as DNA testing. So no DNA testing is allowed on this, these urine specimens. The regulation also then added 3 new fatal flaws. And the reason why we've got a red star there is that if by chance you have fatal flaws defined in your policy, then again you would need to update and add these 3. If you do not have any fatal flaws discussed in your policy, then you would not, of course, need to do this. Okay. But essentially, these are flaws that are logical and they make sense, and they just needed to clarify the regulation just to make sure each of these were covered. So again, if there's no chain of custody control form with the urine specimen at the labs, in other words, the specimen shows up, but there's no chain of custody and control form, that's a fatal flaw. Or if the chain of custody and control form shows up, but there's no urine specimen, but one was collected, that would be a fatal flaw. Or if by chance there were two separate collections, but only one chain of custody control form. So a matter of clarifying those rare, but things that can happen. There was also a clarification regarding what collection site personnel are supposed to do when there's insufficient volume. Previously, they were to, if there was a possibility of adulteration, they were to keep it and send it off as well. But now it's been made very, very clear that if there is insufficient volume, always that initial specimen will be discarded. And that obviously the specimen that then is collected following the insufficient volume procedures that are defined in Part 40, that is the specimen of record. There are also some changes with the chain of custody and control form to address and to reflect the changes that have been made in this final rule. One of them is they've basically taking the word DOT out of step 1D. Basically just there's no necessity for that. It's kind of redundancy, so they're taking out the word DOT there in 1D. But also under step 5A, where the results of the test are to be recorded, it's now being revised to add the additional 4 opioids that we discussed previously. Anytime there's a change in custody and control forms, it needs to be very clear as far as when you need to use the new forms and when you need to stop using the old forms. So that has, in fact, that guidance or that has been provided in this regulation. The new chain of custody and control form, individuals, collection sites can start using it as early as January 1 of 2018. But it doesn't have to be. If you still got old chain of custody and control forms at the collection site, those can still be used through June 30th of 2018. In doing so, it doesn't need to have a correction. There doesn't need to be a memorandum for the record required for any of the old forms that are used through June 30th of 2018. But all of those old forms the use of those need to be discontinued by July 1. And so beginning July 1, that's when the new forms have to be utilized. The reason why we have a red star here is it would be a good best practice to have discussions with your collection sites to make sure that they are making the appropriate arrangements to get those new forms and to make sure that they're actually in use by July 1 of 2000. There are some minor miscellaneous changes. Some outdated compliance dates have been changed, some minor editorial corrections. The links have been revised and updated, as well as there were some minor changes and revisions to appendix items. Okay, so that's an overview of the regulation and those changes. What I want to do right now is go over the changes that employers would be required to do. Okay, so this whole page should have a big red star on it. Okay. Every employer who's covered by the DOT, Drug and Alcohol Testing Rule, all of their policies should be looked at in fine detail, and everywhere that there is the word opiate, that needs to be changed to opioid. Okay, so that would be a required change. If in your policy you have a breakdown of the 5-panel drug, the subcategories, whether it includes the cutoff levels or whether it's just a detailed description of them, If you, in fact, have those in your current policy, then they either need to be removed or edited to reflect these 4 additional opioids. Also, if you have definitions included, there are a number of those definitions that were updated or revised, as we'd indicate earlier in this presentation, and so you'll want to make sure that all those definitions are, in fact, updated accordingly. Those are what we have interpreted and what appears to be required by the DOT. Obviously, everybody on this webinar should really refer to their own legal personnel and human resource experts to read the rule and to make sure that you make the necessary modifications consistent with your interpretation of that regulation. And again, it's likely that, especially with FTA, the next copy of the quarterly updates will also have a discussion of this as well. But what we have presented thus far is our humble interpretation of what the required changes will be. Okay. However, there are also a number of best practices that are not required by the DOT, but that are best practices that we would suggest employers might consider as they are looking to implement this program or this regulatory change within their organizations. Okay. Primarily how it addresses significant safety risk and the additional procedure that is identified regarding, the MRO and the MRO's interaction with the employee regarding significant safety risk, and the employee's responsibility to facilitate contact between the prescribing physician and the MRO. If by chance in your policy you already have a section of some kind that addresses prescription over-the-counter medication, we would suggest to you that that might be a place where you might want to address those provisions. If by chance you don't have a section like that in your policy, you might want to consider adding a section to your policy that does address, being medically unqualified and significant safety risks, and that you define the process here and what are the requirements and what the employee's responsibilities are. So again, because we don't know everybody's policy, we can't give specific direction as far as what those policies say and where it needs to say it, but these are some suggestions that we have as far as a best practice. Other best practices that are not specifically required by the regulation, but that we would advise as again as a best practice, is that we would suggest that there needs to be some employee education regarding the regulatory changes and what that is going to mean as far as employees' responsibility. ODAPC has created a very short notice to employees that is on their website, and we've got that referenced later on in this presentation. But that's something that you might want to share with your employees. You might also want to share with your employees and review with them your policy changes and have a general discussion on prescriptions and how they might need to interact and discuss their job duties and the way this testing process might play out with their prescribing physician. It also might be beneficial to explain to employees that they want to make sure that their prescribing physician is as informed to the best of their ability as far as what their job duties are. So if in the fact they are ever given a call or they're ever asked to talk with the MRO, they are familiar and aware of what those job duties are so that they can communicate to the MRO regarding those potential safety risks. Similarly, as we've indicated throughout the presentation, even though it may not be required, it would be prudent for employers to communicate with their service agents to make sure that they are aware of the regulatory changes and what that means for them. Make sure that, again, it would be a best practice to give them a copy of the revised regulation and to give them the link on how to sign up for ODAPSI's listserv. It might be a good practice to get some kind of documentation that that service agent actually did sign up. I believe that it's important for employers and employees to know that when it comes to the issue of significant safety risk, that the DOT has essentially given that final word to the MRO. In other words, it's the MRO's discretion. Now, we are anticipating that ODAPSI will be publishing MRO guidance, revised MRO guidance, and that we anticipate that that will be forthcoming shortly to help MROs understand what the expectation is and to help guide them through the process. However, we do not anticipate that that guidance is going to give concrete, definitive answers on some on how all of these determinations may be made, because again, every case is going to have to be made on a case-by-case basis. Okay, so again, if an MRO, in their own personal judgment, believes that there's a potential safety risk, that MRO will initiate this process. It's quite possible that different MROs might have different take on that set of circumstances. So it's important that we realize and that there's a discussion with your MRO to make sure that everybody's understanding how this is going to be addressed. There are some possible implications that I believe employers should be prepared for, and that is it's quite possible. The reality is that some employees may have difficulty accessing their prescribing physician to facilitate that contact. Okay. Also, there can be the issue of how old can a prescription be? Will an MRO accept a prescription that's 5 years old or 6 years old, you know, if it says take as needed? And there may be a problem with potentially even if an employee has not had recent contact, for example, with the prescribing physician, it's quite possible if there's that dialogue between the MRO and the prescribing physician may or may not feel comfortable in making an assessment of a safety risk or not. All of these things are not spelled out in the regulation. Again, it's up to the discretion of the MRO given the soon-to-be published MRO guidance, but we just want to make sure that there are some potential possible implications here. What employers need to know of as early as January 1, they could potentially get a telephone call from an MRO that would indicate that an individual safety-sensitive employee might have a significant safety risk. Okay? And so unless it's got to do with the USDOT and medical standards, like a CDL medical standards, essentially there is no USDOT regulation that then guides or tells that employer what to do when they get that phone call. So the regulation stops at the phone call. So you as the employer will then have to determine what it is you're going to do now that you've been told that one of your employees may pose a significant safety risk. It is a best practice for you to think through and be proactive about what you're going to do if by chance you do get that telephone call. You know, we can just say that it's not a DOT regulation at all, but best practice has been that some employers are creating fitness for duty or wellness policies that will address that so that they can be proactive in the set of circumstances where they get that call. It also potentially could be subject to, you know, collective bargaining concerns. Okay. So the most important thing is to be prepared for what happens on January 1, get that call, and to be prepared with what it is that your organization feels most comfortable with. We highly recommend, since it's out of the auspices of the regulation, that this would be an opportunity where you really need to talk with your legal counsel and with your human resource experts within your agency in order to be able to determine how you as an organization are going to address those potential calls. Okay. With that, I think that pretty much ends the formal part of the presentation. We will try to address questions to the best of our ability. And again, we'll try to get through as many as we can. If we can't get through them all, then you'll be able to email them. Like one of the things that we may be doing if people have a concern is possibly in January we may perform another webinar that does deal with the fitness for duty best practices. Again, that would be outside of the purview of the regulation. And it would basically be just a webinar on best practices. But if there's interest, we very well may be able to do that as early as January. I do want to point out that, again, the reminder that this recording is on the National RTAP's website. There will be different versions, or the version of this on these slides will be provided or available to webinar attendees. And we also did reference the fact that there are a number of resources that might be available to you. So we want to make sure that you are aware that if you go to ODAPC's website, which is right here, you can actually get a copy of the final rule. There's a brief summary of the changes. There is information regarding the chain of custody and control form implementation. There's a discussion about policy changes, and there's a discussion or the employee notice as well. So with that, we'll open it up to questions.
So, Robbie, the most common question beyond if the slides will be what if the employee cannot get in contact with their prescribing physician within that 5 business day requirement?
I think that's a very good question. It's a very practical question. At this point, the only thing we have is the regulation that says they've got 5 days to facilitate that contact. One could assume from that, and this is an interpretation, well, hopefully FTA will and the DOT will continue to provide and shed light on that. But again, it would be if there is no information provided by the prescribing physician the MRO will have to be making their determination about whether there's a safety risk or not, just based on the information that they have available to them at the time. And so assumption is that if there's no contact and if they've not gotten any additional information, that the MRO who had that concern will probably be contacting the employer at the end of that 5-day period, and will be telling that employer that there's the potential for a safety risk assessment here. Now, what I want to point out here is the ultimate decision about whether there is a safety risk and what you do about it really falls on the employer. In other words, the MRO is going to suggest to the employer that there is a safety risk, but it's up to the employer to make that final determination, and then to decide what to do with that employee once they have that information. And again, it's there's all kinds of opportunity for various internal procedures about what you do when you get that information. Some best practices have been to basically take that individual, out of safety-sensitive duties until such time as that question can be answered to the satisfaction of the employer. Some agencies may wish to refer that employee for a complete fitness for duty assessment. I mean, there are a number of different things that employer can do, but whatever those are, we just need to know that they're really outside of the auspices of these regulations, and that the employers will need to come up with those procedures on their own.
Another question is, can you provide a real example, a live example of what you think might cause someone to be a significant safety concern?
I think a significant safety concern would be if the MRO has been able to validate that an individual may have a prescription, or maybe even multiple prescriptions for opioids. But they have valid prescriptions. But at the same time, maybe they have multiple valid prescriptions. And so in that particular case, the test result would be negative because there's a valid prescription, but there would be something regarding that prescription, either the quantification or the number or anything else, something else that was that the MRO found out when they were discussing the usage of this medication with the employee that would cause them to have a concern. Again, it could be not only the use of prescriptions, multiple prescriptions, maybe interactions of prescriptions, or it could actually be the condition that the employee was using the medications for.
Another question is, will the significant safety risk 5-day issue with contacting the prescribing physician and the MRO, will that slow down getting the results of the test?
I believe that the test results will be verified in its normal time frame as either positive or negative. That the safety assessment should not impact that.
One says, if the driver is taking prescription or over-the-counter medication, is it only required at the time of the testing to notify the MRO or the prescribing physician, or are they automatically unfit for duty for not having reported?
The requirement to report any prescriptions or over-the-counter medications is, unless it follows the CDL provisions, really is an employer requirement as far as reporting prescription over-the-counter medications. So it really is up to the policy of the employer.
One other question said, well, if we have to make sure our service agents are on the listserv, how can we actually document it beyond just asking them to sign up? Robbie, as they asked that question, I found out if you're already signed up and you go to the website to re-sign up, the website will tell you you're already signed up. So that's the way you can document it. Ask them to go sign up again, and if it tells them they're already signed up, then they can print that screen and keep it on file. And then, of course, if they're not signed up, you can have them, and then when they sign up, the website will give them a confirmation screen saying.
And again, that's a best practice.
The requirement is that they sign up. The best practice is that you help them sign up. So the burden is on them, but we would definitely suggest that you help them. Other multiple questions is, are there any sample fitness for duty wellness policy templates?
Should we go forward with another webinar a little bit later on in January? We will be discussing that, as well as at the FTA National Drug and Alcohol Conference that will be held in May. There will be a whole session on this. There have been, FTA did publish a prescription over-the-counter medication toolkit a few years back that does have some sample policies in it. But obviously anything that was done years ago would have to be updated to reflect, you know, the provisions of this new regulation. Again, I'm sure that there will be more and more examples as individuals and as employers are able to respond to this, and as you know, that information is available. Hopefully we'll be able to present some additional best practices in a future webinar.
Another question said that ODAPSY's website said that there should be no need for policy changes if the policy, drug and alcohol policy, simply refers to Part 40 for procedures. So the question is essentially, if our policy does say we will do testing in accordance with Part 40, do we need to change our policy, versus if the policy actually breaks down what the procedures are, how will we have to change our policy?
Yes, you are correct. If you basically have covered all the testing procedures with one line that says you will follow 49 CFR Part 40 as amended, and I want to make sure you kind of add that little part in there, as amended, and then you would not have to change anything else. I would just make sure that as you're reading through your policy that there just aren't other references to definitions, the word opiates, and some of these other things that you know, might be scattered throughout the policy. So I would make sure you give it a real good review to make sure that you haven't you know, overlooked something.
Somebody asked about how this impacts, or if it impacts, medical marijuana.
It does not impact medical marijuana at all. THC is still you know, one of the 5 drugs that's tested for a positive for still going to be positive regardless of the source, unless it comes from a valid prescription from Marinol. So as a reminder, the federal government does not recognize the medicinal use of marijuana other than for Marinol.
Last question before we turn it back over to National RTAP. Is an employer required to remove an employee from safety-sensitive duties during this 5-day period?
The way that it is supposed to work, the employer will not even know necessarily that there is a safety risk at this point. Again, the employer will be told that the test is negative or positive, or, you know, they'll tell that it's negative, but it's not until the MRO has had the opportunity to discuss with the prescribing physician 5 days has occurred before the MRO will make a determination about whether or not there is a potential safety risk. So the employer should not know during that 5 days that there's even necessarily a concern.
One last one came in, I think. Would the MRO consider a driver using methadone or Suboxone as safety?
Don't test for either of those substances as part of this testing with the modifications. Now, if by chance in a discussion with the employee for something else that then becomes knowledge of the MRO, then the MRO would again basically deal with that just like they would any other possible safety risk. But that information would come from some other source other than the DOT, the laboratory test results, because we do test for those substances.
Okay, Liz, if you want to take it back over for your final slides.
Sure. Okay. Well, again, if you have any additional questions, you can email us at info@nationalrtap.org. and we can either try to answer those questions or we can incorporate them in the future webinar that Robbie mentioned in January. So at this time, I would like to thank Robbie and Sean for a great presentation today, hopefully helpful for all of you. And I want to thank you all for attending. As a reminder, the recording, the Q&A document, and a version of these slides will be posted on our website at nationalrtap.org/webinars. And that will be within 1 week, but hopefully later this week. And transcripts can be made available upon request. Just want to also say that if this is your first National RTAP webinar or you're not familiar with National RTAP, we're a technical assistance center funded by the Federal Transit Administration, and our mission is to address the training and technical assistance needs of rural and tribal transit operators nationwide and to support state RTAP programs. And our resources and services include webinars, as well as training materials, newsletters, technical briefs, a peer network, web-based resources and tools, and a biennial conference. So please, while you're looking at the recording and other documents, check out the other materials we have on our website. And we really appreciate you attending and wish you all happy holidays. So thank you again to Robbie and Sean, and hope you all have a nice rest of your afternoon. Thank you.